ladies and gentlemen, good afternoon and Assalamualaikum warahmatullahi wabarakatuh to all of you. It is indeed my pleasure to be here on behalf of the Islamic Financial Services Board to share with you some of our initiatives in trying to strengthen the Shari'ah governance framework for institutions offering Islamic financial services. As you may have listened from my Secretary General early this morning, the IFSB, as an association of central banks, monetary authorities, and regulatory and supervisory authorities, basically are mandated to strengthen the prudential and governance framework for institutions offering Islamic financial services, broadly defined to include the banking, capital market, and insurance sectors. Prior to this, again I'm referring to the earlier keynote delivered by my Secretary General, we have been focusing on several standards that build on or complement existing prudential framework issued by internationally recognized bodies. For example, with regard to the banking sector, that would be the Basel Committee for Banking Supervision. With regard to the capital market sector, we refer to the principles on securities regulations as issued by the International Organization for Securities Commission, the IOSCO. And with regard to the insurance sector, we work with the International Association of Insurance Supervisors, IIS. So in my early experience, back in 2004, when I first initiated or started the development of our first standard of corporate governance for institutions offering Islamic financial services, there was basically a few benchmarks or a few international documents that I can refer to. In particular, the OECD Principle of Corporate Governance, which has been issued as early as 1998 and then revised in 2004. Then we also refer to the Basel Committee paper on enhancing corporate governance for banking organizations that was first issued in 1999 and then revised in 2006. Similarly, when I was working on the collective corporate governance for Islamic collective investment scheme, our main reference was the IOSCO principles on collective investment schemes. But when it comes to Shari'ah governance, practically speaking, I have no international document or international benchmark that I can refer to. There are a few different frameworks, a few different systems that have been in practice in many of the leading jurisdictions. So when we were contemplating at developing this standard, we have to basically rely on the wisdom and the experience of our members, the regulatory authorities themselves, on how they have developed different prudential and governance framework for Shari'ah issues in their respective jurisdiction. As mentioned by Professor Rifan, again this morning, he has illustrated very accurately and very illustratively that there are at least 6 different regulatory approaches to Shariah governance out there. Just again to repeat these models for you to better understand where our corporate Shariah governance standard derive its lessons and wisdoms later on. I will just share with you again these models. So the first model basically is where the financial regulator decides that we are a financial regulator, we would not intervene into religious or Sharia issues, and we will let the market decide on what should be the Sharia governance system to be applied by the market. In other words, the first model is no model. The regulator will just let the market decide, and the customers decide what form of Shariah governance system they would be comfortable with and would earn them sufficient credibility to be in the market. The second model, the financial regulator would slightly be concerned with what they consider as market deficiency, the fact that the market might have some level of failures, so they slightly intervene into the market in Shariah compliance issues, for example by setting out fit and proper criteria and setting out Shariah parameters as to what financial contracts can be used or offered in the market. The third model is where we see a more active intervention by the regulators, mainly to provide direction and leadership to their respective jurisdiction. And this is where we see they have their own National Shariah Board or their own higher Shariah Board that becomes the sole authority, the sole body that issues Shariah pronouncements for that jurisdiction. I'm sure, in fact, in my experience, in many of the similar seminars that I've been to, I've heard that most players in the industry would be more comfortable by having a centralized Shariah body. But the fact of the matter, there are only a handful, 5 countries that have got a centralized Shariah body for issuing Shariah pronunciation. Shariah pronouncement. And I can name them offhand: Malaysia, Indonesia, Pakistan, Brunei, and Sudan. So to a large extent, notwithstanding how appealing, how convincing, how this model can provide leadership and direction to the market players, the fact is, it is a practice of the minority among all jurisdictions. In fact, we have to admit and acknowledge that in certain jurisdictions, especially Muslim minority jurisdictions, notwithstanding the fact that there are presence of Islamic finance, the financial regulator are not mandated and would not be allowed by law to have a central Shariah body. I'm referring to countries with Muslim minorities that has presence of Islamic finance, for example, the UK, the US, Hong Kong, Singapore, in fact even China. There are a few of jurisdictions of Muslim minority countries which are also members of IFSB. They are committed to promoting Islamic finance for the benefit of their jurisdiction, and in fact they are very keen in learning the regulatory framework for Islamic finance. This includes Singapore, Hong Kong, China, Japan, Korea. These are our members, and I'm very much encouraged by their commitment in adapting new opportunities in Islamic finance. But the fact of the matter is that they are still in the learning curve, and there are still a lot that, in terms of infrastructure that will need to be done and need to be put in place before we can fine-tune the Shariah governance framework for this jurisdiction, this sort of jurisdictions. And then, even for those, the fourth model, for those countries which have got a higher Shariah board or a central Shariah board, they even would, of course, provide specific processes, specific due processes for the ex-ante and ex-post process, on how to appoint the Shariah board, what kind of reporting should be done by the Shariah board, what are the conditions or the prerequisite for appointment of Shariah board, and even renewal of the contract of the Shariah scholars. So these are, to a large extent, a far more direct intervention into Shariah governance issues in Islamic banks. And then the fifth model, you have basically a new trend, which is very much upcoming, very much becoming well received in the market, whereby you have Shariah advisory firms. So Shari'ah advisory services are no longer in the dominance of individual Shari'ah scholars, but you have firms in which not only they have Shari'ah scholars, but also other professionals like lawyers, accountants, economists, to help them to come up with the best Shari'ah advisory services to provide to the market. And then the sixth model, you have additional institution that intervenes into Shari'ah pronouncement. For example, in the case of Pakistan, in fact, although there is a Shari'ah advisory committee at the central bank, but in Pakistan, the highest authority to issue Shari'ah pronouncement, even in the Islamic finance context, will be the Federal Shari'ah Court. So the court also plays a role in determining what can and what cannot be done as far as Shari'ah compliance is concerned. And of course, I'm sure many of you are familiar with the recent court intervention in the case of Malaysia, whereby the High Court decided that certain product is not compliant with Shari'ah, and then the decision was reversed by the Shari'ah Court. The Court of Appeal. So these are the diverse models being practiced in different jurisdictions. To be fair to each of these jurisdictions, they strive with whatever modalities and framework that they have. And you cannot actually pinpoint that this framework is better than the other without having the fundamentals right. So you need the preconditions before you can adapt or you can apply any of the models. I'm happy to say that the Shari'ah Governance Standard, IFSB number 10, actually illustrates the existence of these models, and we are bringing to the regulators, to the knowledge of the regulators, that you have these options. Look at it, consider the prerequisites, and then only you decide what would be the model that would work best for your jurisdiction. So you can learn from different experience, even for countries or jurisdictions which are considered as advanced in Islamic finance. They actually did not get there overnight. There's a long learning curve that they have to undergo before the system becomes more well established. Sorry for the very long introduction. I think it's quite important before we get into the nitty-gritty of the standard itself for better understanding. IFSB number 10 is basically, of course, our 10th standard. As I've mentioned to you earlier, most of our work, most of our standards and guiding principles are built on existing prudential framework, such as those introduced by Basel, by IOSCO, by IAIS, but we complement them by addressing the specificities of Islamic finance. So, for example, in the risk management standard, we will focus on the Shari'ah governance issues from the risk perspective. In the capital adequacy standard, we will focus on the Shari'ah compliance issues from the capital adequacy perspective. So, as a result, throughout the earlier 9 standards, we basically have small tidbits of different angles or different approach at looking at Shari'ah governance issues. And this 10th standard is the one that collaborate and try to combine all the earlier wisdom that we have learned from the earlier standards and try to come up with a more coherent approach to good Shari'ah governance framework by focusing on 4 main items or 4 main issues, namely competence, independence, confidentiality, and consistency. A lot has been said about Shari'ah governance, but as far as our early studies has shown, in fact, there has not even been a definition for Shari'ah governance. So, in our view, this standard is the first document that attempt at defining what is meant by Shari'ah governance. fact, if we look into literature, there are already plentiful of literature talking about corporate governance, talking about IT governance, but it has not been enough. There has not been enough literature even to define Shari'ah governance, and we actually attempt to do that through this standard. Of course, we will look into the issues. What are the specific issues that the standard aims to address, and recommend some of the best practice. I'm sorry that I noticed that some of my colleagues here, among the audience, have gone through the exposure draft before. In fact, they have fed me with some of the response during our consultation period. So it's quite it could be slightly boring for you to be reminded of all these issues. Similarly, I've got colleagues here who have attended my public hearing in Singapore and in Abu Dhabi earlier. So I hope that you can bear with me, because others will need to share. We will need to share this knowledge with others who have not had the opportunity to look at the standard. And I will also share with you some of the administrative matters as to when and how the review process and the timetable will be adhered to in issuing the standard for adoption. The Shari'ah Governance Standard is the fourth standards related to governance to be issued by the IFSB. Earlier, as mentioned by Prof. Srifan, in 2007 we issued IFSB number 3, Guiding Principles for Governance for Institutions Offering Only Islamic Financial Services, excluding takaful institution and mutual fund. The reason being IFSB number 6 and IFSB number 8 actually deal specifically with collective investment scheme or mutual fund. And for takaful operation, there's a separate guiding principle on governance, which inshallah will also be issued together with Shari'ah governance principles or Shari'ah governance standard by end of this year. So the objective of IFSB number 10 is first to complement other prudential standards issued by the IFSB. As I mentioned to you earlier, all our earlier standards actually do touch on Shari'ah compliance issues, but only from their respective narrow angle. So we're trying to look at it from a more coherent angle. And that's why we will be highlighting the components of a sound Shari'ah governance system. So we are not saying that one model or this model is better than the rest, but we are saying, or we are trying to suggest that regardless of the models that you adopt, these are the components of a sound Shari'ah governance system that you should consider. And of course, the focus on the various issues that I mentioned: competence, independence, confidentiality, and consistency, which are very important consideration, especially from the regulatory perspective. On this point, I need the appreciation from the audience, because what is considered as important for the market may be slightly different from the perspective of the regulator. The regulator will always look more broadly into the systemic issue rather than institutional issue, and that's why the area or the subject or the items that we try to focus on in all our standards are more directed from the regulatory authorities perspective rather than the market perspective. Although at the end of the day, it is the market players who are supposed to implement this standard. The standard also aims at facilitating better understanding of Shari'ah governance issues. Like I mentioned to you just now, in fact, even when we were having meetings on these standards, not many regulators are actually aware that there are several different models out there. So at least by highlighting these models, they would enlighten most of the regulators on the options and what are the pros and cons of each model. The bottom line is to ensure that stakeholders, especially the regulators, will satisfy themselves that an appropriate and effective Shari'ah governance system is in place before they carry on with business as usual. We also aim at providing an enhanced transparency in terms of issuance and audit review process for compliance with Shari'ah rulings. This means that we also try or aim at educating the regulators on what are the issues, what are the areas, what are the items that should be disclosed, and you should look into in the practice of the market players. You should inquire into the practice of the market players before you are satisfied with the soundness of their Shariah governance framework. And finally, by having done to a certain extent harmonizing the due processes, whether at the ex-ante level or ex-post level, we hope to provide greater harmonization of Shariah governance structures and procedures across jurisdictions. Definition of Shariah governance system. So in our context, in our document, we refer, there is a deliberate intention in choosing the word system there, okay? Because it encompasses a very broad framework. It is not entailing or envisaging a single process or a small number of processes, but rather a very broad stage of processes that cover the whole operation of the institution. And that's why Shariah governance system, the system, refers to the set of institutional and organizational arrangement through which an IFS ensures that there is an effective, independent oversight of Shariah compliance over each of the following structure and process. So there are ex-ante process before the product is offered in the market, and there are ex-post processes on whereby you monitor the compliance side of the product throughout the offering of those products. What is involved in the ex-ante? Firstly, of course, the issuance of the Shariah resolutions to endorse the product itself as Shariah compliant, and secondly, to ensure that the Shariah resolutions or pronouncements are disseminated throughout each layer of the operation, which means that records or information on Shariah resolution should not be in the domain of the Shariah officer only or Shariah board members only. It is even more important for the people on the ground, the salesperson, the clerk who works on the counters, who offers this product, to understand and learn about the Shariah resolutions that have approved the products offered by the bank, so that they will be able to guide customers on what actually are being offered. As far as ex-post processes are concerned, we are hoping to see a better periodic internal Shariah review process. Depending on the size of the firm, you can either do it quarterly, semi-annually or annually. Of course, the larger the bank is, the more regular periodic internal review should be carried out. I'm aware of several very large Islamic banks which actually carry out the periodic review monthly. But at the same time, for probably smaller type of product, smaller type of operation, product offering or type or operation, you don't actually necessarily need to have monthly or quarterly review. Probably semi-annually or annual review is sufficient. And of course, for the benefit of the regulator in particular, there must be an annual Shariah review so that the regulator will be in a better position to monitor the compliance side of the institution. So if we try to frame out the various processes, the various preconditions required in the Shariah governance system, we have the competence, independence, confidentiality, and consistency. I mean, basically, consistency is right on the left-hand side. Sorry, on the right-hand side. On the consideration that by having due competence, independence, and confidentiality processes, you will reach a reasonable reasonable level of consistency. So for each processor, there must be ex-ante, there must be ex-post. Ex-ante, for example, for first portfolio screening, before you invest into any product or invest into any project, there must be portfolio screening on Shariah compliant aspect of the product. Purification, ex-post, which means that after you have invested, you find out that the product or the stock or the project is tainted with non-Shariah compliant income, you must have due process to purify those income. Independence. So there must be independence compliance check before the product is offered in the market, and similarly there must be independent internal and external review process after the product has gone into the market. Confidentiality. In all our earlier standards, we actually have been promoting transparency because we believe that there has still not enough, insufficient transparency level as far as Shariah governance practices is concerned in the marketplace. But at the same time, we thought that it is timely for us to introduce the need to also observe confidentiality rights and duties of the Shariah scholars, whereby among others they must acknowledge the intellectual property, the development rights of the product held by the institution, and that's why they must respect an undertaking of secrecy before they serve the institution. And similarly, whenever they depart from observing that confidentiality requirement, they must be able to either comply or explain why they need to depart from certain opinion or certain views in undertaking their duties. Of course, when we talk about competence, there must be, for example, minimum skill sets, minimum fit and proper criteria before anyone can serve the Shariah board or even the internal Shariah unit. I mean, what's the point of having a Shariah governance due process if the person undertaking it are not equipped with minimum skill set? Similarly, in due recognition of the lack of competent people, there must be an effort to share the responsibility, and this is where collective wisdom has to be put in place. It means that the due process itself must promote collective wisdom, and that's why in the IFSB standard, for example, we are saying that Shariah governance responsibilities, although they are led by Shariah boards, but they are not within the domain of solely the Shariah boards. Even the board of directors, the senior management, the auditors, whether internal or external auditors, as well as officers who run the operation, have their own responsibility, their own share of responsibility in ensuring Shariah compliance. And this is where we actually believe that collective wisdom will work better to promote sound governance, because there is sufficient facts, sufficient proofs that we cannot totally depend on Shariah scholars simply because of the fact that they don't have time, they don't have enough expertise, they don't have even the prerequisite skills to carry out everything that is expected from them, unless they are probably in the top 20 list of the top Shariah scholars. So that's why the burden of complying with Shariah will be lesser felt if there is a collective wisdom in place that we incorporate through the Shariah governance system. There must be adequate processes to safeguard independence in the Shariah governance system. Independence of the Shariah board, independence of the internal Shariah compliance unit, the independence of the Shariah internal Shariah review unit, as well as the external reviewer, if any. And that's why the reporting and communication channel, the line of accountability, can play a part in ensuring that, for example, the senior management would not meddle with the independence of the Shariah board and those persons responsible for Shariah compliance. In terms of confidentiality, there must be full understanding of the level of confidentiality expected from the various organs of governance and the impacts of leaking this information without due process. And there is also a need to understand that with regard to balancing between confidentiality and transparency, the important aspect is to look at the stakeholders, the broad interest of the various stakeholders in Islamic financial services, whereby you cannot simply favor one party or one stakeholder over the other without looking into the whole issue. So how does IFSB 10 differ from the earlier IFSB principles? Because all, as I mentioned to you just now, all our earlier principles do touch on Islamic, on Shariah compliance. But how does it differ in this case? Firstly, with regard to the scope. So earlier we have not properly defined Shariah governance system because we were looking at it only from certain narrow perspectives such as risk management and corporate governance or capital adequacy. But here we actually define it as well as other key terminologies. We also cover all types of IFS, so regardless of whether banks, collective investment scheme, fund management companies, takaful undertaking, and Islamic window, they are similar expectation. I would not say the same expectation, but similar expectation across all types of players with regard to Shariah compliance. Instead of repeating structures and processes that govern relationship between Shariah Board and IFS, the IFSB 10 focus on 4 elements required for an effective Shariah governance system, which means that regardless of any one of the 6 models that I mentioned to you just now with regard to regulatory approach to Shariah governance system, we are saying that in each of these models, you do need competence, you do need independence, you must have observation of confidentiality, and finally, all these processes must promote consistency in different ways. And then, in terms of the structures and processes, we try to provide a more elaborate and prescriptive suggestion and recommendation on what should be the best practices. For example, in terms of competence, we set out in the appendices the terms of reference, which we actually borrow, we actually take out from the fit and proper test, the terms of reference as introduced in most of the jurisdiction that has introduced this criteria in their jurisdiction, the code of ethics for each of the Shariah scholars. In terms of independence, we basically make recommendation on how to manage this conflict of interest. So there was, for example, there is a suggestion this morning whether by having the salary of or the remuneration of the Shariah scholar being paid by the institution, isn't that a direct conflict of interest? My answer to that is simple, no. Because if that is the approach or that is the perspective that we take, that means that no one can be paid by the bank. Not the lawyers, not the accountants, not the auditors, not even the board of directors, which is illogical, impragmatic. So you don't manage conflict simply by looking at the remuneration package or the remuneration system, but rather the whole governance system. For example, no matter how much you pay your Shariah board, but if they know that their conduct is governed by certain ethics, certain rules of ethics, if they know that their contract will be reviewed, for example, at the end of each term by the national authority, by the national supervisory authority, if they know that they will need to disclose in the annual report what type of fatwa or what type of Shariah pronouncement that they make for each of the products being offered, for me this is sufficient to manage that conflict, because transparency and disclosure helps a lot in managing those conflicts. In fact, you can even put in the due processes, in the decision-making process for your Shariah board, that if there is a personal conflict, for example, that product is being introduced or being financially engineered by a family member of the Shariah board, then he should restrain himself from voting for that product. So there's a lot of other areas or other aspects that you can introduce to manage conflict, which we believe should be considered as well. Confidentiality, we basically inform the Shariah board on what should be authorized or unauthorized disclosures so that they will be more guided. And then consistency, of course, is a drive towards convergence. I have to skip some of the slides. Of course, you will be able to read most of this even in the document itself. It is still easily downloadable for free on the IFSB website. But basically, these are the three main premises when we develop the standard. We hope for a coherence whereby the whole standard actually do not work on itself. It has to be read together with the other standards as well, and there must be a coherence of implementation between this standard and other standards. No single model, no one size fits all, because we cannot say that one party or one board, because there was a suggestion just now whether there should be an international Shari'ah board. The question is that not only whether this is pragmatic, but also whether it is reasonable. Would that one board, all-knowing, be all-knowing, have no tendency to make mistake? Would that one board would not be prone to political influence? I don't think so. So to a large extent, it would be even better. In fact, we have to bring ourselves back to the wisdom of differences of opinion among the Ummah is a blessing. By not having a single model, because we can actually learn a lot from having different models, and then only over time, by having earned sufficient experience over all these models, then only we can pick and choose what works for our jurisdiction or what works for our institution. Because no one institution, no one jurisdiction can say that it is better than the other, without having the prerequisites of each model. And of course, sharing responsibility between all members, all organs of governance in the institution, as I mentioned before. IFSB 10 covers 5 parts. The first part relates to general governance approach, whereby we define the ex-ante and ex-post processes. In part 2, we focus on competence, suggesting various measures to ensure reasonable expertise and skills. In part 3, we aim at safeguarding the independence of Shari'ah board. Part 4, emphasizes on the importance of observing and preserving confidentiality. And part 5 focuses on improving consistency in terms of professionalism of the members of the Shari'ah board. So part 1, general governance approach. The main principle says that the governance structure adopted should be commensurate and proportionate with the size, complexity and nature of its business. And that's why we are not promoting one single model. You can adopt whichever model that works for you, but there must at least be an assurance of competence, independence, consistency and confidentiality. General governance approach principle number 2 is IFS must ensure that Shari'ah board has clear terms of reference. Sad to say that until now we still hear a lot of cases whereby the Shari'ah board do not even have appropriate terms of reference. Basically, they are given a blanket duty to just oversee Shari'ah compliance aspect without even that aspect being defined. What do you mean by Shari'ah compliance? Which school of thoughts, for example, are you referring to when you say this is Shari'ah compliance and this is not? Well-defined operating procedures and lines of reporting, which is very important to ensure and safeguard independence. Good understanding of and familiarity with professional ethics and conduct, especially for the younger generation of scholars, which we hope to be able to carry themselves in a more professional manner compared to older scholars, because the challenges that are faced by the industry at the moment is much more heavier, much more difficult compared to the early days of the industry. Competence, principle 2.1, IFS shall ensure that any person mandated with overseeing Shari'ah governance system fulfills an acceptable fit and proper criteria. This is easier said than done. We are trying our best to recommend some fit and proper tests, but it varies from jurisdiction to jurisdiction as to whether it is pragmatic to implement. Because the more strict you implement the fit and proper test, it would mean the lesser number of Shari'ah scholars will qualify. While you also acknowledge that the demand is very high, the market is indeed in need of more Shari'ah scholars. So this is a balance that you will need to look into. Principle 2.2, IFS shall facilitate continuous professional development of persons serving on the Shari'ah board. as well as the Internal Shari'ah Compliance Unit and Internal Shari'ah Review Unit, if any. Because we are trying to suggest that let's carve out and manage the conflict of interest. Scholars, just like any other advisors to the banks, any other officers of the bank, should not be serving on so many boards. You wouldn't have enough time, if you think carefully, to dedicate time, skills, and dedication to diligently look into Shariah compliance issues if you sit on so many boards. So there's a direct conflict there. But how do you complement the training needs and the exposure of the Shariah scholars if they are not sitting on so many boards? And our recommendation is that the IFS should take the responsibility in facilitating the continuous professional training. There should be a formal assessment of effectiveness of the Shariah board. We are suggesting that there must be performance appraisal for the Shariah board. Then only you would make the Shariah scholars, even the compliance officers and the review officers more accountable to their duties. Sorry, Ashra. I'm sorry for the short of time, but this is quite important. I will just walk this through quickly. Independence, of course, cannot be overemphasized, and that's why among the adequate tool for good independence is that we are promoting complete, adequate, and timely information to be disclosed to the Shariah board prior to all meetings and on all ongoing basis. Which means that if, for example, the scholars require assistance, lawyers, economists, or accountants to provide them with a better understanding of the product, the IFS is duty bound to provide them with the independent assistance. Principle 4.1, Shariah board members should ensure that internal information obtained in their course of duties is kept confidential. This is quite easy to manage as long as you properly define what is confidential and what not, and make them understand why certain things are confidential and why certain things are not. Of course, by having all this due process, we hope that there will be consistency. The consistency also relates to the legal and regulatory framework in each jurisdiction. Quite unfortunately, we see until now, because of the lack of intervention from the regulators, even in the same jurisdiction, you will have different Shariah opinion, confusing the market as to what is permissible and what not. So we are actually looking at the regulator taking more proactive steps on this. The public consultation has been undertaken for 5 months throughout January to May, whereby we hope to seek public views on the adequacy of the choice of technologies, compatibility of the recommendation with their local Shariah governance framework, and any additional recommendation of the best practices. We have 2 public hearings, namely in Singapore and in Abu Dhabi. By the end of the deadline, we received written comment from 22 organizations, 3 individuals, as well as our own Arabic editing committee who translates the exposure draft. In general, it was very well received. No major changes to the principle itself, only a few changes to the recommended practices. And these are the timelines that we are looking at the IFSB. We are hoping that by November of this year, inshallah, during the council meeting in Kuala Lumpur, we will be able to adopt the standard as IFSB number